Hi, Anthony Verna here. I'm back, and let's talk a little bit about a decision that came from the Trademark Trial and Appeal Board on October 31st. But first, it reminded me of a case a few years ago that I had, where I made my appearance in the case, and opposing counsel about 2 weeks later filed a motion for sanctions. Why did opposing counsel want to sanction me when I was only involved in the case for 2 weeks? Well, my client was really not forthcoming in giving his dates for his trial testimony. Now, my client being the plaintiff really did need to state his case at some point. So opposing counsel did call him for his testimony, and since he was foreign, he really was reluctant. But since I had only been in the case for 2 weeks, the Trademark Trial and Appeal Board said that no appropriate type of sanction in this trademark dispute was really going to be appropriate. So no sanctions were needed. Also, at some point, we did give a date for my client's testimony, and we worked it out. Now, this case on October 31st came from the makers of Tito's Vodka. That's called Fifth Generation, and they were filing to cancel trademarks from a company called Tito Mirov Vodka. Now, Tito Mirov Vodka and Tito's Vodka have had disputes since 2016. And one of the issues was that Tito Mirov said that the only board member that could be in the United States really isn't in the United States, and therefore could not provide any particular testimony as to the cases. Well, after a filing, the Trademark Trial and Appeal Board found that this particular company, well, might have been lying about that. And that's been a part of the reason for the sanctions. What were the sanctions? All of Tito Mirov Vodka's trademarks were canceled by the Trademark Trial and Appeal Board, and therefore no trademarks are registered here in the United States by this particular company anymore. But it was fraudulent filings, it was repeated violation of court orders, and it was repeated inability to put witnesses up for testimony, which is a big reminder. When there are disputes in the Trademark Trial and Appeal Board, it is a federal court of law. It might be an administrative court, but it is a federal court of law. And discovery requests are court orders, subpoenas are court orders, any kind of testimony is done under penalty of perjury. It's a federal court of law, and that's the key with this particular case. And that court does have the power to put harsh sanctions for business practicality. And canceling all trademarks, while that is a very harsh sanction, does come into play. So remember, if your trademark is in dispute and you're in the Trademark Trial and Appeal Board, you'll want to take that case as seriously as if it were a trademark infringement case in any federal district court. I'm Anthony Verna, managing partner of Verna Law, where we focus on IP and advertising law. See you next time. Thank you.